For this assignment, I'll be doing a legal analysis of national origin discrimination involving the Latino and Hispanic community. Title VII of the Civil Rights Act of 1964 guarantees equal employment opportunities for all. It prohibits employers from discriminating against employees or candidates due to protected classes, such as race, religion, sex, and national origin. When it comes to national origin, employees or possible candidates are discriminated against often due to their ancestry, ethnicity, language, or accent. This has a significant negative impact on the United States Latino and Hispanic population, which is the largest ethnic minority group in the United States. Their population is also only increasing, and it is expected to represent 25% of the United States population by the year 2050. The EEOC is responsible for enforcing Title VII violations, and when it comes to the Hispanic population, unfair policies include requiring employees to speak English even when it isn't necessary for the job. The first case I'll be discussing is Vasquez versus the County of Los Angeles. In this case, probation officer Francisco Vasquez sued his employer, Los Angeles County, claiming they discriminated against him due to his ethnicity, resulting in a hostile work environment. His supervisor harassed him with several stereotypical and offensive comments between the period of February 1998 to March 1999. When he reported these allegations to the director of the facility, the supervisor in question retaliated by sending Vasquez a memo demanding every instance in which he felt harassed at work. That March, the harassment culminated with Vasquez receiving a transfer as well as a written warning due to allegedly directly disobeying that same supervisor. In this case, we see an example of disparate treatment due to the overt and obvious nature of the offensive stereotypical comments made right to Mr. Vasquez's face by his supervisor. In June 1999, he filed a discrimination claim with the EEOC and took disability leave until August due to stress and depression. Initially, the district court took the side of the employer, claiming his employment was not adversely affected. Upon appeal, the federal courts ultimately decide with Vasquez, deciding that the terms and conditions of employment changed due to the frequent and distressing harassment by his supervisor, as well as the facility's failure to stop the behavior once they became aware of it. The important takeaway from this case is just how hard it can be to prove instances of workplace discrimination. Even though his supervisor made offensive comments directly to his face repeatedly, and even then, it was just his word against hers initially, until it went for appeal to the higher federal court. The second case I'll be discussing is Cruz versus Coach Stores. Yvette Cruz worked at a Coach store in June 1994 when she was allegedly promised an upcoming promotion to the position of Coordinator of Operations Systems. In November 1995, still with no promotion, she was fired due to having a physical confrontation with a coworker. She quickly filed a complaint with the EEOC, claiming Coach failed to promote her due to her Hispanic origin. When she brought Coach to the district court, they sided with Coach because they claimed she was fired due to the physical confrontation, which is not a protected activity. The Court of Appeals found much more damaging evidence for Coach, including the behavior of Human Resources Manager Rick Bloom. He was known around the store as someone who commonly uses vulgar obscenities when referring to Hispanics, along with highly offensive comments. They ruled that his behavior was severe or pervasive enough to adversely affect Cruz's employment. In conclusion, the Court of Appeals affirmed the district court in most aspects, including failure to promote, except they overturned their ruling regarding a hostile work environment, claiming that she did, in fact, experience those conditions. They agreed that Coach was not liable for failure to promote because Cruz never even formally filled out the application for the position she claimed she was promised. They also affirmed the district court's denial of wrongful termination, agreeing that her firing was due to the physical confrontation rather than her Hispanic origin or any other protected class or activity. This is another example of disparate treatment due to manager Rick Bloom's blatant offensive, and disparaging comments and jokes about people of a Hispanic ethnicity. It's crucial to analyze cases such as these because they show the importance of focusing on the aspects of discrimination that are easiest to prove when you're part of a lawsuit involving your employer. Because in her initial district court case, she focused mostly on the fact that she felt she was wrongly terminated and that they failed to promote her as promised, the courts overlooked that she did in fact work in a hostile environment. The third and final case I'll be discussing is Hernandez versus Yellow Transportation. Two Mexican Americans, Ruben Hernandez and Abe Trevino, were employees of a Dallas trucking company who claimed they were forced to work in a hostile environment due to harassment about their Mexican ethnicity. A third worker, John Ketterer, who was Caucasian, made hostile workplace claims as well, alleging it was due to his protected activity of protesting the company's mistreatment of ethnic minorities. The district court initially sided with Yellow Transportation on all claims. However, the Court of Appeals then found that Hernandez and Trevino had each experienced two separate incidents of harassment for a combined total of 4 incidents. Despite this, the Court of Appeals affirmed the ruling by the district court. They claim that experiencing only 2 incidences of harassment in over 10 years of working for each of them was not enough to be considered a hostile work environment. They made the same determination for Ketterer, determining that he was also not the victim of a hostile work environment, as well as that he didn't face any retaliation claims. They made this determination by making the determination that the workplace was an all around unpleasant environment filled with insults and rude behavior, and that there was no proof that directly made it obvious and clear that it was due to his protected activity of protesting. It's important to study and analyze this case to realize and understand that many victims of workplace harassment never receive the justice they deserve. What we can take away from this is that it's always essential to record detailed and proper documentation of exactly what happened, when it happened, as well as who was around to witness it, if anyone. In conclusion, analyzing cases like these are crucial to both understanding how they took place as well as how to prevent them from recurring in the future. It's beneficial to examine some cases that are about disparate treatment in addition to others that have disparate impact. No matter if the discrimination is overt or subtle, it always results in unequal employment opportunity. The biggest lesson I personally learned from analyzing these cases is that the only way to truly stop workplace discrimination is to have a detailed, zero tolerance policy for any harassment and to strictly enforce it. The reason this is so important is that workplace or companies themselves rather can be held liable if they are made aware of the discriminatory behavior and don't do everything in their power to stop it from continuing. Thank you.